All right, we're going to get started if everyone can take a seat. So I'd like to welcome everyone, say good morning, and thank you for joining us. We're pleased to have so many patent experts and stakeholders joining us here in person in Stanford, as well as those joining in one of our regional offices or watching online through our web portal. As you know, today's roundtable is a continuation of our previous forum held just this past month on patent subject matter eligibility. Last month, we focused on ways that the USPTO could improve our subject matter eligibility guidance and training examples. And today we are seeking a broader perspective on the overall issue of the legal contours of eligible subject matter in the US patent system. Your feedback will help us foster the discussion of this critical and challenging issue. As a brief housekeeping note, because today's event is being transcribed and webcast, I would ask all participants to speak clearly so that we can accurately capture everything that's been said. Each panel today will be followed by a Q&A period for our USPTO panel here to interact with the stakeholder panelists who will be seated over there. And in-person audience members can submit written questions using the cards that are provided at your seats in the room. Please give them to Ken Takita or Julie Mason, who are here in the red shirts. And those of you who are viewing online can also submit questions using the chat function of the webcast, and we will be reading questions from this panel as well. So before we begin with the first panel, it's my pleasure to introduce the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, Michelle Lee, who will be speaking to us via webcast. Michelle.
Thank you very much, Shira. Can you hear me okay?
Yes.
Great. Good morning, everyone, and thank you for coming to this roundtable discussion. I'm sorry I couldn't be there in person with you today due to obligations that are keeping me in Washington, but I am delighted to be able to participate remotely. And I wanted to thank all of you and all the other participants who are participating remotely, including via the web and through our regional offices, other regional offices in Dallas, Denver, and Detroit. And what you'll be seeing more often is as we go forward and as we continue to integrate our regional offices into the core work of the Alexandria office, you'll be seeing more opportunities like this to participate from across the country. So we hope you like it. Give us feedback on how that's working, but that's something that you should keep an eye out for going forward. I appreciate all of your attendance at this very important conference, roundtable, and topic. As I have said many times during my tenure as director, our patent system relies on the full and active involvement of the public to help us not only succeed, but to help us lead in today's global innovation economy. Our agency remains committed to strengthening our patent system wherever possible. Like you, we want a patent system that works efficiently and effectively for all of our users, so we can continue to promote the innovation that drives our nation's economy and creates jobs. Those are the guiding principles behind our efforts, including a pair of roundtable discussions on patent eligible subject matter that I announced in October. The first, as Shira had mentioned, which occurred earlier this month or last month in Alexandria. Today's roundtable focuses on the current Section 101 jurisprudence and how it is evolving and what is the optimum legal contours of patent eligible subject matter. And before we begin and hear your input, I want to set the stage by briefly describing a bit of background on Section 101 and how we've arrived where we are today, with an emphasis on some recent subject matter eligibility cases and their impacts. As far back as 1897, the statutory language defining patent eligible subject matter has remained largely the same. Aside from the 1952 Patent Act's arguably linguistic change of art to process, the four statutory categories of patent eligible subject matter, process, machine, manufacture, and composition of matter, have largely remained unchanged. For over 100 years, eligibility has been considered a threshold requirement for patentability. supplemented by the other patentability requirements of novelty, non-obviousness, written description, and enablement. While the statutory limits of patent eligibility have largely remained unaltered, innovative advancements across a broad range of endeavors has developed, some unimagined more than 100 years ago. At times, the judiciary has struggled to reach with the reach of eligible subject matter to ensure that patent protection extends only to the application of ideas and not to the ideas per se. The adoption of judicially created exceptions precludes the patentability of abstract ideas, laws of nature, and natural phenomena. Drawing the line between patent-eligible subject matter and the non-eligible exemptions has proven at times to be challenging for courts, for the patent community, for the agency, and for innovators, particularly in recent years. That is why we are here today, to receive your viewpoints on this challenging aspect of patent law. Within just the past 6 years, the court has left us with a handful of decisions that have significantly impacted patent eligibility law and continues to generate substantial public debate. Starting in 2010 with Bilski, the court reduced the Federal Circuit's machine or transformation test from an exclusive test to a merely useful test in the eligibility analysis. In that case, the court held that Bilski's claims were invalid because they were directed to a judicial exception, the abstract idea of hedging risk, and added only well-known random analysis techniques, which the court regarded as token post-solution activities or components. Following Bilski, the Supreme Court caught the life sciences community's attention in Mayo versus Prometheus when it considered the patent eligibility of a method for optimizing drug dosages for treatment of autoimmune diseases. The court held that Prometheus's claimed method of determining a given dosage level and whether it's too low or too high based upon the metabolite level was ineligible for a patent as it was drawn to a judicial exception. In making that determination, the court introduced its two-step test for distinguishing between patent-ineligible concepts from patent-eligible applications of these concepts. The first step of the so-called Mayo test considers whether the claims are directed to one of the judicial exceptions to patentability. If a judicial exception is identified, then the second question is whether the claims do significantly more than simply describe the judicial exception. The Mayo test has become the linchpin of the Supreme Court's patent eligibility analysis, as made evident in many recent cases. In a second case to impact the life sciences community, Association for Molecular Pathology versus Myriad, the court held that Myriad's claimed isolated gene products useful in assessing hereditary predisposition for developing breast cancer fell squarely within the law of nature exception, while acknowledging that claims to a product with markedly different characteristics found in nature may be patent eligible. Determined that Myriad's genes did not undergo any chemical changes during isolation. The court did, however, hold that Myriad's synthetically created cDNAs, which differed from the naturally occurring DNA, were patent eligible. Most recently, in Alice versus CLS Bank, the court applied the Mayo two-step test to analyze eligibility of a computer-based method for mitigating settlement risk in financial transactions. The court concluded that the claims were directed to the abstract idea of intermediated settlement, and that mere generic computer implementation did not transform the abstract idea into a patent-eligible invention. During the past 2.5 years since Alice, the Federal Circuit has been applying the Mayo test to a variety of technologies invalidating many claimed inventions. The precedent set by the Supreme Court cases has unquestionably impacted the innovation community. I'd like to thank each of today's panelists in advance for discussing the extent of that impact and whether and what steps should be taken to further support inventions that we all desire. We're calling on you to help create a public record on Section 101 jurisprudence by providing information on how the Supreme Court and Federal Circuit Section 101 jurisprudence is affecting different areas of technology, and whether and to what extent there is any impact on investment in research and development or innovation generally. Additionally, we're calling upon you for comments on whether legislative, administrative, or judicial changes are needed or desirable, and if so, what those changes might look like. In sum, today we continue to assess whether the current state of patent-eligible subject matter law and the accompanying judicial exceptions are best serving innovation. So I want to thank you all again for attending today and for your contributions to the larger discussion on patent-eligible subject matter. We welcome your input on this complex and important topic. And with that, allow me to turn it over to our moderator of today's program, Nate Kelly. And thank you all. I look forward to a productive discussion, which I will be watching via the web here in Alexandria, Virginia. Thanks so much.
Thanks, Michelle, and thanks for setting us up here today with really a brief and great overview of where we are, at least where I think we are in the 101 space. Before I get started this morning, I just want to introduce those of us from the PTO you see up here today. To my left is Shira Perlmutter. She's the USPTO's Chief Policy Officer and Director for International Affairs. And to her left is Bob Barr, the USPTO's Deputy Commissioner for Patent Examination Policy. To my right is Amy Nelson, an Associate Solicitor in the Solicitor's Office with a very deep background in the life sciences area. And to her right is John Kubekta, the USPTO's Director of its Silicon Valley Regional Office. Now, later this afternoon, you're going to see a different panel of people from the USPTO up here. Some people are going to change out, and I'll let them introduce themselves. And what's happening now on my left, with the panel being ushered in, is what's going to happen throughout the day. So the way we've decided to handle so many people, and we were very happy with the interest that we got, is we're going to have about 7 panels of 6 or 7 speakers for each panel. We'll have 4 panels in the morning with a 10-minute break between the first 2 panels and the second 2. Then we'll have lunch, and in the afternoon we'll have 3 more panels. On each panel, each speaker has about 7.5 minutes to speak. If we deviate from that, whoever's moderating will tell you. We do ask the speakers to stay on time as much as possible. In order to get through 40 or so speakers in a day, we really can't have each person running over even 30 seconds or a minute. And to that end, for those of you who ever argued in the Federal Circuit, we have the exact clock that you'll see in that courtroom. When the light turns from green to yellow, it means you have a minute left, and when it turns from yellow to red, it means you have no time left. And we'd appreciate it if you wrap it up at that point, and please start wrapping up when you see the yellow light. We'll go through each speaker one at a time, 7.5 minutes each for this panel. For each panel, we've built in about 10 or 15 minutes for us to ask questions. If people in the audience would like to suggest a question, there's cards that you can write your question on, and I think there's people in the regional offices and at our home office in Alexandria to also assist in that. We will ask the questions if the card is brought to us, and it's not our intent to have a fulsome question and answer period for each panel, but if a question comes up, we built in a little bit of time to ask it. That time is also the time we need to trade out from panel to panel. I think that, oh yeah, let me say one more thing before we begin. We're very excited with the interest that we got when we put out our announcement, but of course, in addition to the comments that we'll hear today and those that we heard a couple of weeks ago in Alexandria, we also would really like to hear from people in written comments. And the period for written comments is open and will remain open until January 18th. So if you'd like to comment, if you hear something today you'd like to reflect on, if you're speaking today and haven't filed written comments, please do so, because that's really where we're going to get a lot of very good information. And so with that, let me turn it over to the first panel. And our first panelist this morning is Frank Bernstein. I hope I'm saying that correctly. Mr. Bernstein? Good morning. Yes? No?
No, we have somebody on the web.
Yes. Oh, I'm sorry. You're right. It's right here in front of me. Our first speaker this morning is actually not seated before you here at Stanford, but is in Alexandria, Virginia, and it's Neil Thomas. And forgive me, I apologize, Mr. Thomas. Please go ahead.
We can see him.
is our system of commerce has no physical or concrete existence. Hello?
Mr. Thomas, Mr. Thomas, can I ask you to begin again? I'm sorry, can I ask you to start over because we had a little technical difficulty. And here in the room, we couldn't hear you. I don't know if people online could hear you, but we couldn't hear, and I'd like us to get everything you have to say. So please just go ahead and start over.
Slide 2, please.
Thank you.
Slide 2. Alice changed the very definition of abstract. Abstract meaning existing in thought or as an idea, but not having a physical or concrete existence. All of a sudden, our economic system, fundamental economic practices, our system of commerce has no physical or concrete existence. This is absolutely laughable. Next slide, please. Alice did not follow Bilski. Bilski, Fluke, Deere all dealt with mathematical formulas as abstract ideas. Bilski, the opinion, the concept, quote, the concept of hedging, quote, reduced to a mathematical formula is an unpatentable abstract idea, just like the algorithms at issue in Benson and Fluke. Next slide, please. Alice did not follow Bilski. The opinion in Bilski, like the risk hedging in Bilski, intermediated settlements, quote, a fundamental economic practice. All the claims at issue in Bilski were abstract ideas in the understanding that risk hedging was a fundamental economic practice. This is a crucial distinction. It extrapolated in a tectonic manner the concept of abstract to our system of commerce. This is not what Bilski decided. Next slide, please. Ergo, in light of Alice, advertising, negotiating, selling, inventory, ordering, banking, paying, pledging, communicating, keeping records, etc. are all fundamental economic practices. Ergo, they are all abstract. Examiners indicate that displaying information, collecting and comparing known information, processing, storing data, electronic record keeping, again, transmitting data over networks, are all ineligible abstract ideas. This extrapolation is absurdly ludicrous. Next slide, please. Alice, following Mayo, introduced an awkward two-step test and totally undefined inventive concept, significantly more, and nothing of substance. There's no indication whether these are the same or different tests. All of these, are they the same or different? Or simply a new and useful, unobvious process, machine, or improvement thereof. Next slide, please. Alice is bad law. It is unnecessary, simply adding confusion. Alice could and should have simply been decided using section 101 and 103. Performing a well-known fundamental economic practice using a generic computer is likely obvious. Next slide, please. On top of Alice's illogical decision, for over 2 years, 2.5 years, examiners are issuing copy-paste boilerplate rejections, particularly in 705, 3600 TC 3600 art unit. And managers and supervisors apparently are requiring these rejections even after a complete reversal by the PTAB. Next slide, please. This aberration can be seen where 90% of rejections in electronic art units have occurred. Next slide. As well as nearly half of all applications with an Alice rejection are assigned to class 705. This next slide, please. This is e-commerce. This is the internet. Section 101 is still law. Congress has given no directive to exclude a whole field of processes and machines, and inhibiting innovation in e-commerce, improving consumer protection, and increased competition. Next slide, please. Digital trade is, in fact, America's third largest category of experts. Intellectual property is a critical element to this trade, and software and information services is increasingly important. Yet Alice and the Patent Office are inhibiting our economic position in global and international trade. Next slide, please. I don't see any red things. So the Trump administration is looking for improved protection of America's intellectual property, which would produce more than 2 million more jobs right here in the United States. Next slide, please. After 2.5 years, inventors, particularly in 3600 art, are unjustly deprived of their intellectual property, unjustly forced to make lengthy and costly appeals. Investment capital has been severely impacted, and contingency fee patent enforcement litigators have all but disappeared from the marketplace. By the way, they're the ones that help small inventors. Next slide, please. Congress enacted 101 and 103 and are still a law. Circuit Court Judge Newman, in her concurring separate opinion, proposed returning to the letter of Section 101. A new and useful process or machine is not an abstract idea. And a trend is clearly appearing in Bascom and EnFish to simply look for unobvious improvements or unobvious improvements. Next slide, please. The Patent Office must require examiners to consider the elements as an ordered combination in light of the specification and look for an inventive concept and, at the same time, a new and useful machine or improvement under 101 or 103 and 103. Examiners must follow MPEP and specifically rebut applicants' arguments, not simply dismiss, quote, applicants' arguments are not persuasive, close quote. Require examiners to consider both the Alice eligibility and at the same time 101 and 103 tests for patentability in tandem and arrive at the same conclusion. Next slide, please. Automatically audit every Alice rejection with an independent Alice expert, including a 1-hour mandatory interview, 1/2 of which is to the examiner, 1/2 is to the applicant by the same independent Alice expert. Incentivize and provide consequences for poor, improper rejections. Next slide, please.
We're going to have to move on, but I know that your materials have been provided on our website, and I urge people to refer to them.
Okay, thank you.
Thank you very much. Our next speaker this morning is now Mr. Frank Bernstein.
Good morning. I'm Frank Bernstein. I'm a patent attorney and prosecutor and litigator in the computer implemented inventions area for about 30 years, a patent attorney here and practitioner here in Silicon Valley. I want to unpack this notion of abstract idea just a little bit. If you go to the second slide, please. This is one of the things that we're wrestling with in the computer implemented invention area, and the Federal Circuit, in a case which I'm going to go into a little bit more detail, the EnFish case, acknowledged that there's no specific definition. We're doing this by example, by comparison with other software cases to determine whether an idea is abstract. And one of the issues we have is that at some level, almost any software-based claim can be said to be directed to an abstract idea, even if something that's overtly physical, like controlling a robot. or a robot's movement. Next slide, please. So the Federal Circuit started out in the EnFish case, I've got the cites in my slides, quoting the Alice decision, saying we must first determine whether the claims at issue are directed to a patent-ineligible concept. The court went on to say, and this is important, that formulation of the Supreme Court plainly contemplates that the first step of the inquiry is a meaningful one. That is, that a substantial class of claims are not directed to a patent-ineligible concept. So that it shouldn't be a reflex action to simply decide that a computer-implemented invention is directed to an abstract idea. Next slide, please. The Federal Circuit contrasted this notion of claims being directed to a patent-ineligible concept, which is what the language of the Supreme Court, with whether the claims involve a patent-ineligible concept. The Federal Circuit said you can't look at whether it involves a patent-ineligible concept because essentially every routinely patent-eligible claim involving physical products and actions involves a law of nature and or natural phenomenon because these things take place in the physical world, and that's something that's important to remember. Next slide, please. One of the things I always go back to, and I've got a little enough hair in my head and enough gray in my beard to remember when there was a big interplay between software and hardwired processors. And software is supposed to run on generic hardware. It does what hardware did. We have lots better generic processors now, general purpose processors. I honestly think the Federal Circuit got it right in Allopat 20 years ago when it said every time you program a general purpose processor, you've got a new machine. And I really think that should be the inquiry. Software is a multi-trillion-dollar business in this country. It's supposed to reduce or eliminate the need for special purpose hardware. It's supposed to accomplish what circuits and circuit elements accomplished. Next slide, please. Back to the Federal Circuit decision, bouncing back and forth here just a little bit, but just to give some context for some of the discussion, Federal Circuit said software can make non-abstract improvements to computer technology just as hardware improvements can. And that's important. That's this byplay between what software does on a general purpose processor and what special purpose processors, which were much more prevalent back in the day, did. The court also said sometimes these improvements can be accomplished through either route, through software or through hardware. So it's relevant to ask whether the claims are directed to an improvement to computer functionality versus being directed to an abstract idea, even at the first step of the Alice analysis. In other words, you're not supposed to just gloss over this notion of abstract idea and get to the significantly more thing at the second step of the test. You're supposed to look in the first instance at whether there's an abstract idea and whether there's an improvement to computer functionality, because that can inform the analysis and the conclusions. Next slide, please. We know beyond discussion that a circuit arrangement is patent eligible. The patentability analysis, if you're looking at a circuit, proceeds immediately in those kinds of cases, provided the circuit arrangement is claimed sufficiently clearly and in a manner which defines over the prior art, the claim will be patentable. You don't worry about eligibility or ineligibility. Next slide, please. So again, looking back at the EnFish case, the Federal Circuit goes on and says, the first step in the Alice inquiry asks whether the focus of the claims is on the specific asserted improvement in computer capabilities. That's, or instead on a process that qualifies as an abstract idea for which computers are invoked merely as a tool. It's a helpful comment. It's important to remember that general purpose processors are tools. You program them, you have essentially a new machine, and you're looking at that as a measure of what the improvement over, or should look at that as the measure of what the improvement over the art is. Next slide, please. The whole notion here is that software does run on generic hardware. It's the point of having software. I remember from prosecuting circuits cases, you've got transistors, diodes, capacitors, what have you, in various combinations to accomplish certain things, and you've got to define those and recite them with sufficient specificity to define over the prior art. Maybe all we're talking about here is a matter of instead of just functionally claiming what's going on, have the software recite a little more specifically what it's doing to turn the computer into a new machine. Maybe that's how the software can be shown to be more than merely a tool. And also, again, a way, maybe that's how the software can be shown to improve computer capabilities. Next slide, please. The question is, does that go far enough? What does it really mean to improve computer capabilities? Does the computer really have to run better? That was the discussion in the NFISH case when they talked about the spreadsheet and how it ran better from the way it was programmed. But shouldn't it be, or should it be enough that the program computer just simply does its intended job better? If you wind up, you program a processor that's that's controlling the movement of a robot, and you improve the control with better programming, why not look at that in comparison with the prior art instead of deciding that it's an abstract idea? In that context, what is it that I have to be able to show? Do I have to be able to show that the software improves the functioning of the computer? I don't think so. And that's really all I have. Thanks very much.
Thank you very much, Mr. Bernstein. And our next speaker this morning is Robin Feldman. Professor?
Thank you. I'm Robin Feldman, Professor of Law at the University of California, Hastings. One of the great joys of being an academic is the ability to speak with candor, and so I offer my remarks this morning in the spirit of that hallowed tradition. In law, as in so much of life, there is an arc of history. We may move forward with slow and fitful gait, but the trajectory is often clear. The question for this agency, it seems to me, is whether to follow that arc or to push against it. With patentable subject matter, the modern arc began with the first of the Quartet Alice cases, Supreme Court cases, and with each step, some in the bench and bar have tried to wipe it away, explaining why the trajectory was no more than an optical illusion. Couldn't be, it mustn't be, and I confess there are times when I have joined that chorus as well. This has had no more effect than whistling into the wind, and there's little reason to believe that pressing against the arc of history will be any more successful going forward than it has been in the past. So for example, after Bilski, we said the court didn't eliminate machine or transformation, so everything is pretty much business as usual. With Mayo and Myriad, the refrain was, that's only for life science cases. And since Alice, the refrain has been, they didn't ban software patenting, so we'll find a way. Many circuit decisions during this quartet period have come perilously close to what I would call reversal from below. And through the entire time, the fervently whispered prayer has been that the Supreme Court will get tired of patent law or tired of being criticized and will leave us to do what we do best. But the justices have not tired of patent law, and in fact, patent law continues to occupy a remarkable amount, an unusual amount of their docket. And reversal from below is a treacherous path, one that is usually unsuccessful in the long run. The latest wave of Federal Circuit decisions, software decisions, again pushes back on the Supreme Court's trajectory. Yes, many, many software patents have been invalidated under Alice. And it's a two-step process in which a court must first determine whether the claim is directed to a forbidden category, such as abstract ideas, and then second, whether the claim adds significantly more. But after taking some time, the Federal Circuit has found ways to ease the two-step tango. The Amdocs case opined that there is no workable definition of an abstract idea. The NFISH case held that courts must be careful not to apply too high a level of abstraction. And the McRow holding is best summed up by the patently O headline, Step One, don't assume an abstract idea. Now, as much as one might hope, it is hard to imagine that this wave of Federal Circuit decisions will be greeted any more warmly by the Supreme Court than the last. So some on both sides of the question of how broadly patents should reach have hoped that Congress will intervene, either by overturning the Supreme Court's subject matter decisions or accelerating and enhancing the court's decisions, or even cutting back on aspects of post-grant review from the American Invents Act. None of the tea leaves, however, suggests that Congress is likely to weigh in at this point. So what's an agency to do, as it is buffeted by the winds of this less than cordial interchange between two levels of the judiciary? And of course, the agency itself may have internal cheering sections for particular viewpoints, not to mention pressure from those who use its services. The Patent Office, however, has an unusual level of responsibility as an agency, given the 20-year lag time once a patent has been granted and the nature of modern patent markets. For example, there was a time we could say with confidence that 90% of patents would never garner a return. Those shadow patents hovered on the periphery of the innovation system, doing little damage. But the world has changed. With modern secondary markets, patents are easily traded, grouped, launched as a bundle against product-producing companies. In particular, this fall's Federal Trade Commission report on patent assertion entities concluded that for an entire category of players in the patent market, the business model is a nuisance one. And while the number of patent lawsuits has gone up and down in the last few years, the down years are still vastly above the number 8 years ago, even accounting for changes brought about by the American Invents Act. The burden on innovation industries is not small. As we sit here in Silicon Valley, I note that the work of many scholars has carefully documented the damage modern patent assertion is causing for startups and small enterprises, not to mention more mature companies. And the Patent Office has come into more than its fair share of blame. The 2013 GAO report pointed at poor patent quality as a cause of pain in the patent system. And the problems are not just in the tech industry. Weak life science patents contribute to schemes that are fueling popular outrage about rising drug prices. In short, the burden on the Patent Office to get it right is great. And when the agency follows the ebb and flow of the battle between different levels of the judiciary, that strategy can leave long-term damage in its wake. The rules may change when the issues reach the Supreme Court, but for patents granted in the interim, there is a 20-year tail. Thus, I urge a large dose of caution. The temptation to jump forward as the Federal Circuit pushes back on Supreme Court doctrine misses the arc of history. And while we may not like it, the arc of history is clearly there for us. Thank you very much.
Thank you, Professor. And now we'll hear from Mark Lemley. Professor Lemley.
Thank you. My name is Mark Lemley. Welcome to Stanford. I teach law here at Stanford. I'm also a partner at the law firm of Dury Tongri, where I do patent litigation. So I want to agree, at least conceptually, with Robin, although I think we might disagree about some specific applications. I want to agree with Robin in saying that I hear and understand the frustration with the Alice test, the claims that it is ahistorical, the claims that it doesn't draw great lines. I think as a practical matter, complaining about it is not actually going to do very much. And I also think as a practical matter, something very interesting has happened in the 2 years since Alice, which is even though I find Section 101 jurisprudence intellectually offensive because there doesn't seem to be a there, the courts, I think, are actually engaging in a common law process that, with some exceptions, mostly in the software world at least, gets them to the right result in particular cases. So there was a lot of panic and concern after Alice, I think, that, well, nothing's going to be patentable in the software and the business method world. But I think we're starting to see the development of common law jurisprudence that actually does draw some distinctions that we can look to in trying to understand what's going to be patentable and what's not. So I part ways, I think, with Robin on the question of whether or not a case like EnFish, for instance, is flying in the face of the Supreme Court's jurisprudence. I actually think the Supreme Court did not intend, right, and would not hold, if it were presented with the question, that software is not patentable, or that software is not patentable unless there's new hardware attached to it. As Frank points out, that's a kind of distinction that doesn't make a lot of sense as a scientific matter. I do think the court was reacting to a very real problem, which is that we have a whole bunch of patents, particularly issued in the 1990s and the early 2000s, that are written in extremely broad functional terms, that don't claim a particular way of improving the operation of a computer, or a particular way of using a computer to improve the operation of something else, a particular algorithm. They claim any computer programmed in any way to achieve a result. And the problem with those claims is precisely that they are not directed to a technological improvement. Even if they started from a technological improvement, we have all, as lawyers for many years, told people, write your claims as broadly as possible, reach as broadly as possible. And those claims made it into the courts, where it turned out that the courts were not terribly well equipped to deal with them using standard tools. And it's right, I think, intellectually to say obviousness can take care of this problem. Maybe Section 112 can take care of this problem. But we've designed the legal system in litigation in such a way that you're not going to get to that conclusion until the very end of the process. You're going to hand it to a jury. You're going to spend several $1 million in the process of getting there. And for the business model that Robin talked about, where the goal of filing the lawsuit is to impose costs on the defendant in order to get a cost of value nuisance settlement, these patents were gold, right? Everyone infringes them because they cover any possible way of achieving this result. And while they are probably invalid for obviousness or enablement at the end of the day, it's going to be a long, expensive, and uncertain process to get there. So the patentable subject matter case law, while I find it intellectually unsatisfying, has had in software a mostly desirable practical effect, which is it's allowed us to weed out at an early stage a number of claims that should die on some ground. And if you look at the cases, the patents that have died since Alice in the Federal Circuit, honestly, most of them deserve to die. Those claims were too broad. Those claims were not, in fact, written to be designed to specific technology. The worry that we had, which was, is this just going to sweep too broadly? Are we going to reach all software? Are we going to reach claims regardless of how they're written and how they're narrowed? I think that worry is now looking less and less problematic as we see a bunch of Federal Circuit cases from within the last year that actually draw a distinction between inventions that are directed to, patent claims that are directed to an algorithm, to a specific approach, to an actual improvement in computer technology. Those claims are surviving 101 in the patentable in the Federal Circuit, and I think deservedly so. Now, that's a common law process, right? Courts are good at, lawyers are good at, looking at 30, 40, 50, 100 examples, seeing which ones get held unpatentable, seeing which ones get held patentable, and kind of coming up with a kind of rough set of standards that's going to give us an instinct as to which bucket each claim is going to fall into in the future. That instinct should get better over time. That analogic reasoning is what lawyers do. It's what litigators do. It doesn't provide us with particularly useful rules, and I think that's a problem for the Patent Office, right? Because if the goal is to write guidelines that examiners who are not lawyers versed in analogic reasoning can use to decide, hey, this claim is more like EnFish than it is like TLI Communications, that guidance, I think, is never going to be simple and easy to write. I mean, you can use examples, you can use analogies, but it's hard to say, okay, here's how you apply the two-step test, and here's what falls in each bucket. Because I think we're doing it not by applying a simple legal rule. I don't think there is a simple legal rule. We're doing it by looking at a kind of estimate of how technological the invention is, and I think technological includes not just hardware, but software, properly so. Is this patent actually directed at a new software approach? Is it directed at a new algorithm? Is it directed at a new implementation of a computer technology that allows you to do something different? I do think that we can learn some practical lessons. First, the broader the scope of the patent is, the more problematic it's likely to be. The abstract idea concept, I think, is directed not so much at is it removed from the physical world, but is it claimed at a level that cuts across physical world boundaries, where it doesn't matter how I implemented it in software. And second, I think we can pay a lot more attention than we have in the past to functional claiming. A lot of the patents that are most problematic are problematic because they are written in functional terms, anything that achieves this function, but have not been subject to the traditional rules of Section 112F. Both applicants and examiners can use Section 112F to narrow down claims to specific technology, assuming the patent application actually describes specific technology. And in the course of doing that, I think we can at least make the software world a better place.
So next we'll hear, sorry, thanks, Professor. So next we'll hear from Peter Su. Mr. Su?
Okay, thank you. Good morning. My name is Peter Su. I'm a partner at Denton's Silicon Valley office. And before going to law, I work as a design engineer in Silicon Valley. The view I express here are my personal views, not my firm's position on this topic, and my perspective are mostly based on my personal observations working with the inventors in engineering rather than in life sciences. So picking up on the point that Professor Landy talked about useful rules, I have 3 points to share. So first, the Alice framework of abstract idea is difficult to comprehend and apply by the inventors in the high-tech industry. In determining patent eligibility under the Alice framework as to whether the claims are directed to an abstract idea, this is a framework that's hard for engineers to understand and provide comment. So the concept of whether an idea is abstract as a framework to determine 101. So when we analyze whether an invention is compared to if we analyze whether an invention is new or obvious, engineers frequently are able to provide helpful comment on the technical differences between an invention and the prior art. However, if you were to ask an engineer whether the concept is abstract or not, the engineer would likely be somewhat perplexed and not be able to provide his or her opinion. So whether if something is abstract or not is typically not a concept that's taught or understood in engineering schools or in the high-tech industry. So a patent is a legal/technical document that's directed to and to be understood by one of ordinary skill in the art. If an average engineer is not able to discern whether an invention is an abstract idea, then the Alice framework in determining patent eligibility would be difficult to apply in the real world. Second point, the Alice framework is phrased in the negative, which again makes it difficult to apply in practice. So for example, if you look at 102 and 103, under 102, you can obtain a patent if the claims are novel. In section 103, a patent is patentable if it's non-obvious. So under these two statutory sections, we are seeking for characteristics that are new and that are non-obvious. By and large, most engineers are able to analyze and operate in that framework. But in the Alice 101, a patent is patent eligible if it is not an abstract idea. So rather than stating what it is, the Alice framework is stating what is not. So as an analogy, if I was to say that the fruit that Joe likes is not apple, then that fruit could be orange, pears, grapes, strawberries, or other forms of fruit. Because the Alice framework is articulated in the negative, we have the courts that have different ways of interpreting the 101 and gravitating toward the claims that are abstract. Okay, which is reflected in the statistics many a patent's been invalidated or the patent application that's been rejected. My third point actually is more coming from an international perspective. So although the Alice decision is really a domestic U.S. issue, I think it is interesting to know from an international perspective. So as Professor Lemley talked about the large number of software business method patents that were filed in 2000, and in part, I think after the State Street Bank, you could say that the opening of the floodgate for business method patent has somewhat contributed to the venture investment in e-commerce, social networking, and the sharing economies. I had several foreign patent attorneys commented to me back then that they really like the U.S. patent system because it helps these companies to protect their investments that's made into the company. So while we're having an active discussion in the U.S. on the patentability in view of the Alice decision, China has proposed a revision to the patent examination guideline to allow patenting of business models under Article 25. So the proposal is that the requirement would be that the business models not only does it include business methods and rules, but also technical feature. So, this proposed legislation would, if it gets passed, then would, I guess, somewhat motivate the sort of the landscape on how the companies filing software patents.
Okay, thank you very much, Mr. Su. And our last speaker on the panel this morning is Lee Van Pelt. Mr. Van Pelt?
Thank you very much. I'm a patent prosecutor, and I also am an adjunct professor at Berkeley. The two-part test presents the Patent Office with a daunting task. I think Mark has stated that very well. You look at these 101 cases, and very smart law clerks help smart judges write opinions. They may go on for 20 pages, and at the end of the day, I'd say probably half the people in this room would complain about the opinion and perhaps say it's very hard to understand or it's inconsistent. The Patent Office has to make that determination literally thousands of times a month with a staff of hundreds of examiners. I guess my first input primarily is that whatever time and resources the Patent Office is spending on the guidelines is absolutely worth it. In my view, I don't know who's writing them, but I think they're doing, in general, a very good job of synthesizing the case law into guidelines that someone who has to make this decision several times a day, potentially, with applications, can follow. The task is hard. There sort of is an arc in the cases, but the arc is I think, as Mark has pointed out, actually a pendulum. It's not as simple as looking at the lower courts versus the Supreme Court. I mean, you look at, cases that are pro-eligibility, like Deere and Chakrabarty, and you have to square those with cases that are the other side, like Benson and Fluke. That is hard. The approach the Patent Office seems to be taking in the guidelines with respect to the first question is what is abstract, is to look at examples and try to sort of compare whether the claim under consideration is similar to claims that have been dealt with by the courts. I think that's really all you can do. And I think in the guidelines, to the extent that examples are included and the examples are synthesized from what's in the court case, that is very, very helpful to examiners, and it's very helpful in the process of prosecuting a patent to be able to have those. The recent and the life science examples put out in May, I think, do a very good job of pulling facts from the cases, particularly the Mayo case, and writing them as different claims, example claims that you can look at and try to understand the sort of things to put in a claim that's going to work and the sort of thing that's not going to work. And I guess my main input or request is more of that. It's very helpful. And I'd also add, there are a lot of academics in the room. Probably the best class I had this year in patent prosecution class was going through those examples and asking the students to debate, because every one is sort of like a question presented, eligible or ineligible, and the answer is given. And as a teacher, my greatest fear is being boring, and at least that class, it wasn't boring. And I'd urge, if you get anything from my remarks, I'd say it's really worth spending a significant amount of time with the PTO materials and guidelines and examples, because they are a good way to try to practically deal with this issue. I'm sorry that I can't really enlighten you more on what abstract means, because I struggle with it also. Now, on the second part of the test, what is something more? That question's actually almost as hard, I think. My understanding of it has been improved by looking at the guidelines, and they've pulled some language from the cases that it's something that's not well understood, routine, or conventional. And it's very interesting. I think the person who synthesized that noticed that in whether it's Alice or Bilski or Mayo, there usually is a comment in saying why something's abstract and not patentable, that it's just well understood, routine, conventional, something of that sort. Now, as an engineer, that interests me because it's sort of sounding like something that can have some practical utility in that when I think of those three things, well understood, routine, or conventional versus obvious, it sounds a little bit like a coarse filter and a fine filter. And I think examiners, some really effective examiners, I've seen them kind of use it that way, that they don't have to spend the resources to do a specific search on certain things. They use the 101 and they talk about something being well understood, routine, and conventional. It's up to you if you want to try to argue that something that really is routine is not routine. But usually, I think the practitioner will yield, and it saves time. And that's something I want to emphasize that's very important in the Patent Office making this 101 determination, because every minute that the examiner spends having some sort of philosophical argument about what's abstract and what's not abstract, and there have been some great papers written on trying to answer that question, but every minute the examiner spends on that is a minute the examiner doesn't have to search the prior art, analyze the claim, and improve patent quality, which is ultimately, to my clients that have to deal with patents, that are asserted against them, clarity and patent quality is I think, of utmost importance. So, again, my main comment is the time spent on the guidelines is absolutely worth it. The time spent on the examples is absolutely worth it, and to the extent that can help the examiner to save time in these two ways. One, to have sort of good examples so that the first part of the test can be efficiently dealt with. And then secondly, so the examiner can use it as a tool to sort of sweep out the kind of really routine, conventional part and move on to the part that really requires a prior art search for the obviousness part. I think that is a way that it can be a useful tool for examination. Thank you.
All right. Thank you very much, Mr. Van Pelt. So we have some time for some questions, and I'm going to start it off myself with a question for Mr. Bernstein. In your robotics example, and this is something that has bothered me for a while, when I look at cases like Diamond v. Deere and moving forward, how the Supreme Court continues to shape the law. What is the nature of the invention in your example, and is that a valid question? In other words, is the invention new software? Is the invention a new programmed computer? Or is the invention a new robot? And is that a valid question to be asking? And if so, how does one answer that question? And in what context should it be answered, if at all?
It's a valid question, and it's a good question. I think you can look at it as potentially a new robot or as a new computer. And essentially, and one of the things about the robot example, I mentioned the Allopat case that was decided 20 years ago. And in that case, the Federal Circuit found patentable subject matter. A case decided the same day was In re Warmerdam. And that had to do with controlling a robot. And that was found to be patent ineligible. And when you looked at the claim, you saw that it was a bunch of equations. Nothing was done with the equations. And so in that case, I think it was, like the Fluke case, for example, I think appropriate to say that's not patentable or patent eligible subject matter. But in the case of controlling a robot, if you integrate, if you say how you're improving the control of the robots appropriately, and you mention what you're doing with the calculations, if you've got a bunch of algorithms and stuff in it, kind of like Deere, that ought to be patent eligible. So to come back to your question, I think it's either it's a new robot or it's a new computer. I think either of those questions are appropriate to ask.
Yeah, can I add to that?
Yeah, please.
Yeah, because I also do work in robotics, and I find robotics to be one of the more complicated technology I've worked. And I think unlike electronics and software, robotics, you actually involve high-level software with low-level software interacting with ROS to control the different articulation in the mechanical. So I think all that together, I think probably present a stronger case for eligibility.
Does anybody, I'm just curious, does anybody in the panel think that the Diamond v. Deere case would be vulnerable under today's case law with the way, as Professor Lemley put it, the common law has evolved? Is that case just as strongly favorable to eligibility today as it was when it was decided?
I think it is less strongly favorable to eligibility. So I'll note two things, right? One is that from any practical perspective, Diamond versus Deere overruled Parker versus Fluke. There were two different 5-4 majorities where one justice switched. They said inconsistent things, and a lot of the confusion that's come out of the Supreme Court's case law has been the Supreme Court's insistence on trying to reconcile both of those cases as having good law when they say the opposite thing. In Alice, the way they reconcile the two was really quite interesting, which is they introduced into the history of Diamond versus Deere a specific new piece of hardware and said, well, Diamond versus Deere was patentable because it had this specific new piece of hardware. That was not actually present in the claims of Diamond versus Deere. So the result of that, I think, is that the way the Supreme Court is thinking about Diamond versus Deere in the Alice case, I think, is actually a much narrower proposition than what we all would have thought Diamond versus Deere stood for when it seemed like it was overruling Parker versus Fluke.
So I have a question from the floor for Ms. Feldman, and that is, if you're, as you seem to be advocating, that the recent case law is actually sort of hitting the right balance in the software world, how are small startups supposed to sort of get themselves going and have adequate funding? And I will follow, I think, a second question is, in part to that is, Mr. Su talked about international norms and other countries sort of taking different approaches, and what are, I guess, the international concerns with us being out of step with the rest of the world? Is that something that should be driving this?
Sure. So I suspect the question is worry that if you're cutting back on software patents and you're a little guy, isn't that bad for us? How can we get started? And the patent is a difficult world for the small guy. You get buffeted in both directions. It's difficult to get started. And on the other hand, there's a lot of data showing that a target of patent assertion is the startups, and that hurts them and their ability to raise money. So there's a wonderful wealth of data that's come out in the last few years. The bottom line is that patents is a difficult world for the small person. I do believe, and what I hear increasingly from people in Silicon Valley, is that patents are less important for the funding than they have been historically, in part because things change so quickly in terms of how new software comes out, and in part because of this buffeting back and forth that's happening in the court. So I think that I see as a silver lining for the folks in software. I know it is tempting. I work in a program with software, with startup companies. We provide free legal work for 60 companies a year. I understand their pain intensely, but you also have to step back and ask what's happening in the patent system as a whole and not let one piece of it and our concerns about that piece of it blind us to what's happening in the full system.
Can I add briefly to that?
Sure.
So I think in the software world, there are concerns about will people fund software companies, although it's an empirical question. I don't think we've seen a drop-off, Alice-related drop-off or a move out of software in the venture capital world, but that's something obviously that academics should be testing. From the engineer's perspective, I think it might actually push in the opposite direction. The people who hate software patents the most are software programmers, and while that's not universally true, it is overwhelmingly true in Silicon Valley. So I don't think people are choosing not to start companies because they don't think they will get a patent in the software world. Now, I do want to say this panel has been focused very heavily on software. I think in the biotechnology world, we have a very different situation. I think the law is less clearly moving towards a resolution that's kind of distinguishes good from bad patents, and I think it's also much more important that you have patent protection in the biotech industry because the expense is higher, because the lead time is longer. And so there I'm much more worried about the possibility of losing startup investment.
And can I also add to that? So I think from a China international perspective, I think the commentators, including the AIPLA, view that I think if this revision to a Chinese patent law passes, then essentially China would permit business model or business method patent with a technical feature. Essentially, I think the way they drafted is to take it out of what's equivalent of 101, and then they're just going to the anticipation and non-obviousness analysis. The other consideration, since you was kind of asked in terms of the international framework, is it's in terms of how many other countries have examined under 101, whether it's in China, Japan, and Germany. I think, as most of you know, they sort of operate in a different framework with the technical problem, solution, and effect. So I don't know if at some point that the U.S. would actually look at just like with the patent filing with some sort of harmonization that would actually take into account what other countries applies to 101.
Sure.
So I appreciate Mark reminding us that it's not just tech, that it's also life sciences that we have to worry about. And it's much more fun when Mark and I can agree, but this one I'm going to disagree a little bit on because I've testified twice in Congress in recent months about the schemes that are driving prices up in the drug industry. And not all of those, but some of those are based in weak patents, what I call life cycle management games, what I call, lots of people call that. That is happening within the patent world as well, and it is as important there to make sure that we have appropriate and clear boundaries on the patents granted as it is in tech.
I believe the best way to handle those patents, when you say a weak patent, I think that's a 103 question. 103 is the best way to deal with that problem. It's the best filter.
Does anybody else on the panel up here have a question? I have one final one, but so this came from the audience, and I'm paraphrasing a little bit, but the question is, do you think that the courts have turned abstractness into a binary concept, and is that driving some of the difficulty in analysis? Something's either abstract or it's not abstract. That's a hard thing to get your head around, at least for me.
It is a hard thing to get your head around. I mean, I guess I see it slightly differently. Maybe not. I don't know that I disagree with that statement. I think the way we've structured the Alice test causes us to go look for the abstract concept in every patent claim, and that seems to presuppose that there is an abstract idea, and at some level that might be right, but I think the kind of search for the abstract idea may cause us to find it even when it's not really present in the claim, or the claim is at least not limited to it. And so there have been a couple, I think ENFISH in particular pushes back against that in a useful way and says, hey, we can't assume there is an abstract idea that we're then looking to jump immediately to step two. So I mean, I guess it is a binary choice in a sense, but we might be better off with the binary choice than the alternative, which is kind of let's assume that there is an abstract idea and pull that out in every case, because not every patent claim sort of is directed to something abstract.
I'd take that a step further, maybe flip it and say, maybe assume that there is not an abstract idea. I think a lot of this stuff, when you pull out what's been done by hand or what's been done and just do it on a computer, that's a matter of novelty or obviousness, and I think that's an appropriate space in which to deal with this. Put the thing in front of the patent office. You've got however it's claimed, functionally or otherwise, and see whether there's prior art. I kind of agree with Lee that you should spend the time looking for prior art to see whether an invention is patentable, and not spend as much time on this abstract idea notion.
I think the Supreme Court did think that abstract was a fairly binary notion, and I certainly think that they felt it had a definition. So I don't think that they will warmly greet the notion that the test that they've given has no workable definition. I think there will be some fireworks when that issue goes up, and that we should anticipate that. Look, this is not the first time that an appellate court and the Supreme Court have faced off on which one is the greater expert. We saw this in the 70s with the DC Circuit and the Supreme Court over which one understood administrative procedure better. The Supreme Court generally wins, and we might want to keep this in mind along the way.
Let me ask one international question. So Mr. Su and some others have talked about the different approaches to this issue internationally, and whether in Europe or in other countries. And we had a question from our webcast audience that talked about the value of a comparative analysis of the same cases by the USPTO and by the EPO. So my question is, do you agree that that kind of analysis and that kind of comparison would be useful and or relevant?
Well, I think that comparison is very useful, and it's one of the ways to sort of try to get your head around what's abstract and what's not is this notion in Europe of technical effect, and so I think there is a union between things that have a technical effect and things that are not abstract, and so that is not so much taken up by our course, but I think that that's why a lot of times you are getting the same answer out, as Mark sort of alluded to, that we're getting the cases that should be allowed, probably allowed, and the cases not allowed that probably shouldn't be. And I think the technical effect is as kind of another way to get at abstractness.
Those are actually words that a number of my European clients have seized on right out of the Alice case, where there's a reference to technical effect, and the first reaction I got was, oh, you all are more like us now, because they've been looking at it that way for a really long time, and I think it's a helpful construct.
Thank you. And I don't want to forget about Mr. Thomas back in our headquarters office, and I would want to give you, sir, the opportunity to respond to any of the questions if you'd like to.
Yes, thank you. I think it's imperative to understand the difference between Bilski and Ellis. It was a quantum leap of illogic. It's applied the definition of an abstract idea with no physical or concrete existence to a whole arena, unfortunately, of electronic commerce, computer networking, et cetera, business methods. It's I mean, as shown in one of the slides, the Art Unit 3600 is a huge aberration. Congress has not dictated. There's no precedent for this. I think the Patent Office needs to look extremely closely at what's going on in TC 3600 and 705 patents because of the impact the internet and international digital trade, the importance of those areas to our economy.
Okay, thank you very much, Mr. Thomas, and I want to thank the whole panel for their time here this morning.
Thank you.
And also urge anybody who hasn't yet submitted written comments to do so by January 18th. Thank you, and we'll trade out now for the second panel.
Starting up. There's a say next slide to advance. Okay. All right. Sounds good. You're advancing it, right? So I can just tell you. They're going to actually be advancing. Oh, they're doing it. All the slides are in the same. Speak it pretty loudly. All right. Okay, sure.
Okay, so we'll begin our second panel, and the first speaker on our second panel is from the United States Patent and Trademark Office's Denver Regional Office. Mr. Chirag Patel. Mr. Patel?
Can you hear me all right?
Yes, sir.
Great. Okay. Well, thank you very much for including me on the panel. I'm a patent prosecutor based in Denver, and we are participating from this beautiful Rocky Mountain office here right now. So, we talked a lot about how the case law and common law is advancing in this issue of software patent eligibility and 101 issues. And Professor Lemley mentioned about how, the resolution will come from the courts and the legal analysis. And so I wanted to kind of discuss about this recent case that came out in October of this year, actually, from the Court of Appeals. And it does shed some light on clarifying issues about the eligibility of a software patent claims. This is a case that came from the Eastern District of Virginia, and it's MDocs is the patentee that had 4 patents. They're all rated generally towards accounting and billing systems for network providers. So they talk about how to account for network traffic in a distributed network. You have transactions going all over the network and how they are managed. This large amount of data that somehow needs to be processed. So the case was made that this is a technical problem, and the solution that the claims have is a technical solution. So OpenNet is the defendant that pleaded invalidity for all of the 4 patent, all the claims, and then the majority opinion by judges pleasure. I'm sorry, I'm on the first slide. If you don't mind, a second slide. I'm sorry, if you don't mind moving to. There you go. Okay, there's more detail about what I'm talking about. So judges Pledger and Newman upheld the claims as eligible, and they use all of the recent cases that talk about. Some of this came out for eligibility, some not. They kind of drew a lot of commonalities between the DDR and the BASCOM claims and the analysis. Next slide, please. So there are four patents that are at issue here, and I'm just going to talk about a couple of claims in a couple of these patents. They're all generally similar to each other in terms of the what they cover. So as I said earlier, this is software technology for accounting and billing for network traffic, and the claim was made that we are receiving accounting records from very remote, disparate locations. So there's a first network accounting record from a first source, and the second from the second source, and then the computer code is somehow managing to enhance the first network accounting record using all the data that is collected from all the different locations. And so if you read it at the very high level, it's a pretty short claim. It's a pretty, I would consider broad claim. And a lot of the limitations in here, you would think that, well, probably the examiner is going to come up and say, well, all you're doing is receiving a record, you're correlating it, and then you are using some accounting information to change one accounting record. So you have all seen a lot of rejections that would be in 101 that would say, nope, this is not eligible. But court found this case to be 101 eligible. They kind of focus on the limitation, the third limitation about enhancing the first network accounting record. They went back actually for the 101 analysis to the specification and construed the claim and say that the enhance is construed as to apply a number of field enhancements in a distributed fashion. Well, does it help really? I don't know, but that's where the analysis went. And then they said that distributed processing is a critical advancement over the prior art. So they consider this as an unconventional technological solution to a technological problem. They did talk about in the analysis how there's a massive amount of data that needs to be processed, and this claim or the solution allows you to do that. So next slide, please. And I have some observations about so if this is the case that the court considers to be patent eligible, well, massive data processing is pretty common. Anytime there's massive data processing, can we come up with some language that can help us to couch that as a technological solution? Maybe. As I said before, the law court used a lot of commonalities of the claim terms between DDR Holding and Bascom. As to a practitioner, I would say, look at the claims in those two cases that were held eligible, and kind of, if you can come up with some commonalities in what you're doing in your claims, that might help you in furthering your arguments. Next slide, please. So let's talk briefly about the other one other claim. This is a pretty detailed claim for one of the other patent, and then if you look at all the limitations, it's collecting, it's filtering, it's storing, it's submitting queries, it's outputting, and all these terms are normally would be considered nothing significantly more, not adding anything more significantly by a lot of the examiners under the current guidelines. And again, court went back, in this case also, court went back into the specification and construed the terms. Next slide, please. So court kind of focused on the third limitation, which talked about computer code for completing a plurality of data records. And they went back and said completing is directed towards enhancing a record until all required fields have been populated. And then went back to the arguments about why enhancing was something that was a non-conventional technological solution. So there was a lot of claim construction that was done in this case, even at the 101 analysis, which is usually, one would think that it's not usually done that often. But a couple of things here that I would point out is that, distributed architecture, the court said there's a distributed architecture, and efficiency to minimize impact on networks and system resources is something that is technological solution here. So, a lot of claims that we draft for a lot of our clients deal with, in some ways, minimizing some impact on some part of the system resource. So can we use that in arguments to say this is patent eligible subject matter because of those arguments by the case? That could be useful in the future. Next slide, please. So I wanted to kind of close this out with a few high-level observations and takeaways. There was a lot of discussion about how is the 101 analysis binary or not, and looks like the court here kind of tried to use a flexible approach by emphasizing that, sorry about the typo over there, but the abstract idea has no set meaning. So there's no single universal definition of abstract idea, and they relied on the claim construction beyond what's the plain language in the claims, and on improvements over the prior art. We just discussed a lot in the specifications. And the last slide, please. So one final observation here is also that, again, the analysis of non-binary, and if you're a practitioner, emphasize on the improvements provided by the solutions. If you can discuss more of those improvements in the specification, you can use that later on in making an argument that your claims were patent eligible because of their technological solution, or non-conventional solution to technological problems. There's a dissent by Judge Reyna that is pretty interesting and long if somebody's interested in reading it. But I think with that, I'm going to close. Thank you very much.
Thank you, Mr. Patel. And our next speaker is here at Stanford, Dorothy Auth. Dr. Auth?
Good morning. My name is Dorothy Auth. I'm here representing the New York Intellectual Property Law Association. I'm the immediate past president. We assembled an ad hoc committee in order to prepare for this presentation and think about what the best guidance would be for the USPTO on the question of the larger question of 101 and what might need to be done to correct the place we are right now. The NYIPLA's view is that the Section 101 bar should really be a low bar. It should be a sieve with very large holes. It should hold back ineligible subject matter if it contains patent claims that are directed to a law of nature, abstract idea, or natural phenomena, but it should allow claims to proceed through the further analysis of 101, 103, 102, 103, and 112 if they're particular applications of the abstract idea, law of nature, natural phenomena. The question really is, how can we distinguish between ineligible subject matter and eligible subject matter. And the Supreme Court's opinions in this two-part test articulated by Mayo, Myriad, and Alice have proven to be very problematic, and they don't provide a simple framework to know what the right level of abstraction is for Section 101 analysis. Recently, the Federal Circuit is helping to answer question number 2 of the two-parts test through its analysis of patent-eligible subject matter in, for example, the 2 recent decisions in McGrow and rapid litigation management. In these cases, the Federal Circuit has identified patent-eligible subject matter in both, well, one of each, in computer-related sciences as well as life science, both of which are profoundly affected by this, the Supreme Court's decisions recently. And they focused on the very simple concept of technological improvements in the claim language. And secondly, they also required that the language of the claim, by virtue of this technological improvement, be described in the specification, and that it not preempt the law of nature because the claims are narrowly tailored applications of the natural law or abstract idea, and they're supported in the specification. The common theme is that the specification must explain the technological features and the particular application that specifically recites the claims, and thus ensures that the claims don't preempt the law of nature, abstract idea, or natural phenomena. In the NYIPLA's view, the Section 101 analysis should be considered whether or not the claims include specific steps or elements which render the claimed invention. It should be based upon the definition of what an invention is. And that really goes back to the definition in our statute. It needs to be a useful process, a machine, manufacture, or composition of matter, or an improvement thereof. In particular, the process definition in Section 100B even points out that it can be a process, art, method, and includes a new use of a known process, machine, manufacture, composition of matter, or material. The NYIPLA believes that although the Federal Circuit is moving in the correct direction by focusing on specific recited features in the claims and support in the specification, as well as its requirement that the claimed invention not preempt the law of nature, ultimately, statutory amendment will likely be needed to finally resolve the matter, because we have sort of this push-pull that we've already mentioned between the Federal Circuit and the Supreme Court, and as between the two, as Professor mentioned before, the Supreme Court usually wins. So the NYIPLA would propose that at the end of Section 101, a sentence be added that would say, a claim complying with this section may recite a practical application of a law of nature, abstract idea, or natural phenomena, but may not claim or preempt a law of nature, abstract idea, or natural phenomenon. Such an amendment would clarify the applicable standard for review. Such an amendment would lessen the burden, both on the courts as well as in the USPTO, which currently are expending tremendous resources in trying to understand what standards should be applied in the face of a test it and see and compare it to the other cases that have been decided previously standard. Our goal is to create a Section 101 that focuses on patentable inventions, that clearly defines what falls within the patent-eligible subject matter and what is outside that, and also, as we feel is happening already with the Federal Circuit to a certain extent, and shift the true analysis back to 102, 103, and 112. Thank you.
Thank you very much. And our next speaker this morning will be Steve Chang.
Hello, and thank you for the opportunity to add to the public discourse on subject matter eligibility. My name is Steve Chang, and I currently serve as a director and in-house IP counsel at RPX Corporation. However, I am here today speaking not on behalf of RPX, but as an individual spectator of and participant in the patent ecosystem. I'll spend the next few minutes focusing on the question of whether developments in patent eligibility law should be left primarily to the courts or whether additional administrative initiatives are desirable. Any participant in the patent ecosystem is likely familiar with the individual roles played by the USPTO and the courts, as well as the impact that the Supreme Court's Alice decision has had on their businesses. Indeed, particularly for those dealing with software and business method patents, the decision and its progeny have shifted litigation outcomes and strategies wholesale, devalued entire patent portfolios while arguably increasing the values of those less susceptible to invalidation under post-Alice Section 101, drastically lowered allowance rates in some tech centers and art units, and impacted an unknowable number of key business decisions for many a small business, such as, should I seek patent protection for my idea? However, these are not isolated effects because the participants, whether litigants, licensors, licensees, applicants, and would-be applicants, are often one and the same. And these respective businesses could stand to benefit greatly from consistency in the patent ecosystem as a whole. Although both the Article 3 court system and the USPTO played critical roles in evolving the practical ramifications of developments in patent eligibility law, these roles have traditionally been separate. Thus, if we accept the assumption that consistency in the patent ecosystem is more desirable, perhaps developments in patent eligibility law should be a joint effort. One potential way to increase consistency is by enlarging the boundaries of the deference attributed to the examination process by district courts in their determinations of eligibility. For example, if district courts were to consistently apply the Section 282 presumption of validity to determinations under Section 101, that could potentially prevent many situations in which applicants invest a significant amount of money into prosecuting an application to issuance by overcoming Section 101 rejections, only to have the patent invalidated, for example, in the pleading stage. Since Alice and through the end of Q3 this year, in only 20% of distinct cases rendering a judgment under Section 101 did district court judges even mention the presumption of validity under Section 282. Those cases were largely split, with anti-presumption judges generally following Mayer's concurrence in Ultramercial 3 and the lack of a specific application of Section 282 to Section 101 determinations in recent Supreme Court patent eligibility jurisprudence, including Alice, and pro-presumption judges generally tracking the Supreme Court's broader endorsement of the presumption of validity in Microsoft versus I4I and its progeny. However, in the other 80% of cases, one can only assume that the lack of discussion of Section 282 intimates a lack of application of Section 282. This is difficult to reconcile with the fact that the examining core, with its technical expertise, is well equipped to explore the second step of the Alice-Mayo framework, since whether abstract ideas are integrated into something significantly more should really be relative to one of ordinary skill in the art. However, of the 20-plus litigated patents that issued after Alice, and to be fair, after the 2014 preliminary examination instructions and IEG published, only 3 of those received Alice-based rejections on the merits during examination. Consistently ensuring a more fully developed examination record, especially with respect to Section 101, is a good step toward working with the judiciary to explore the possibility of consistently applying Section 282 across all determinations of validity, including eligibility. Another potential avenue for increasing consistency in patent eligibility determinations is by revisiting amendment practice at the PTAB, which is both the most popular alternative form to district courts for litigating patents, and the single largest source of appeals to the Federal Circuit in 2016. It is difficult to reconcile why an underpinning rationale militating against the application of Section 282 at the PTAB, that is, the patent owner having the ability to amend claims, has not been more liberally applied in the context of Section 101. In particular, movements filing motions to amend in CBM reviews and post-grant reviews face long odds in having to meet shifted burdens to distinguish not only prior art of record, but it's as yet unclear whether when, for example, a petition for CBMR or PGR is instituted only on Section 101 grounds, motions to amend might become easier. For example, by allowing movements to add more details from the disclosure regarding the implementation of claim elements that upon institution of trial were deemed by the board to be preemptive, functionally claimed, and flat-out abstract. Allowing such amendments are largely within the discretion of the PTAB, subject, of course, to the Federal Circuit's holdings in Microsoft versus Proxicon and Nike versus Adidas, and squares with not applying a presumption of validity in post-grant proceedings under the AIA. Further, an increase in the number of motions to amend under Section 101, together with their oppositions to amend, could similarly help to ensure a more fully developed record. I would like to thank the USPTO for inviting public input on a piece of the patent ecosystem that has likely affected every person in here in some way. And I'd also like to thank the RPX research team, including Jake Wexler, for support in this. Thank you.
Thank you, Mr. Chang, and thank you for being able to work in motions to amend even to a 101 roundtable. I've got them on my mind. So next we'll move to Kevin Noonan. Dr. Noonan?
Thanks very much. Thanks for the Patent Office for inviting me, and for all of you for being here. Good morning. I'm Kevin Noonan. I'm a partner at McDonald, Bain & Hulbert & Berghoff, which is a mouthful, so we usually say MBHB, and also one of the authors in the Patent Docs blog, if you're kind enough to read that every day. I hope you are. So I'd like to talk today about my views on the role of the office in interpreting and implementing the recent Supreme Court decisions, as we all do, concerning subject matter eligibility, but I want to do this in the context of separation of powers between what the executive branch is supposed to do and what the judicial branch is supposed to do. And I think it would be a mistake to believe, as unfortunately the Federal Circuit seems to, that the court has spoken definitively about subject matter eligibility. I think that the court would agree. If you remember, during the oral argument in Alice, Justice Breyer said the court didn't intend for the Mayo decision to be the end of development of subject matter eligibility law. He said that rather the court and the principles in Mayo were just meant to sketch the outer shell of the content of what the law should be, suggesting that even the Mayo decision's author didn't think that he was or intended to speak definitively or exclusively or finally on the issue. So I think that if we think about it, that's the proper role for the court. If you remember, Chief Justice Roberts said in the Obamacare decision, National Federation of Independent Business versus Sebelius, the following, I'm going to quote him. He says, "Our permissive reading of these powers is explained in part by a general reticence to invalidate the acts of the nation's elected leaders. Members of this court are vested with the authority to interpret the law. We possess neither the expertise nor the prerogative to make policy judgments. Those decisions are entrusted to our nation's elected leaders, who can be thrown out of office if the people disagree with them." I also think that if you look at the cases, not the other cases in patent eligibility, the courts tried to be parsimonious in its decisions. Myriad, for example, Justice Thomas said, and I'm quoting him again, "We merely hold that genes and the information they encode are not patent eligible under Section 101 simply because they've been isolated from the surrounding genetic material." And if you look carefully at the decisions in Bilski and Bowman and several others, you'll see that the court has tried very, very hard not to make blanket and broad statements. I think that the court understands that it sees patent cases only sporadically, although I understand how these days it doesn't seem that way. And usually the cases are brought to test the limit of a statutory section and to try to probe the law a little, but they're hardly representative cases and they're hardly representative claims. The office, on the other hand, sees all the cases, good and the bad, the eligible and the not eligible, the patentable and the not patentable, and Congress has given the office the authority to sort out what is patentable from what is not. So that experience, in addition to the expertise, both technical and legal, that the office has, is why the court can defer and maybe should under Chevron when the agency applies that expertise in making decisions on patent eligibility. The proper role of the agency is to use this expertise to provide the court with the concrete examples of how the law is applied to each new invention based on its interpretation for the court then to determine whether it's doing the right thing. I think that it's a mistake for the office to act, and I think it did, I understand why they did, but they did initially, that the court has tied its hands or somehow mandated an outcome. One of the blessings of the fact that the court has a rather inconsistent focus on patent law and also its unwillingness to overrule its earlier case law is that it makes it possible to distinguish cases that should be patented from the consequences of some of these decisions. I'll give you an example. One reaction to Myriad was to call generally the whole idea of natural products patenting into question. The consequence of this, if carried to its extreme, would I think honestly be devastating. A recent study by the National Institutes of Health about 1,400 small molecules that were approved by the FDA between 1981 and 2010 showed that about 75% of the antibacterial drugs and 80% of the anti-cancer drugs were natural products or derivatives of natural products, and they would have been unpatentable under a very stringent application of the Myriad test. But the Supreme Court giveth and the Supreme Court taketh away. The Chakrabarty decision provides an easy basis to avoid the outcome. In Chakrabarty, the court said the standard for patent eligibility was that an invention be a product of human ingenuity having a distinctive name, character, and use. The office could rely on that decision to consider a chemical or other product found to be derived from nature to be patent eligible, provided that the composition was changed from its natural state in structure, function, purity, use, consistent with Chakrabarty. And I'll mention that there's a section of the oral argument in Myriad in which Justice Alito probes Chris Hansen from the ACLU about whether somebody had actually found a new plant in a jungle that had a component that could be made into a drug. And even Chris Hansen, even the ACLU said, oh no, that would certainly be patent eligible. That's not what we're talking about. And also remember that in Myriad, after Myriad, Chakrabarty was not only cited there, but it was cited with approval, so I think it's good law. As for the diagnostic method claims, which arguably are the bigger problem in patent eligibility for life sciences, I remember that each and every step of the claim in Mayo was routine, conventional, and well understood because it had actually been practiced in the prior art. There was nothing new in that claim except the recognition of the boundaries as to what was and was not effective. So good law exists, and people have talked about Deere already, that mandates the office look at the claim as a whole. And if you avoid the piecemeal application of the Alice test, one after the other, I think you get to that. Now, if you look at the guidances the office has come out with most recently, I think that this has shown a tendency to not slavishly follow what was believed that the court said, but rather to interpret and distinguish. But I think that you know, if you are to understand Mayo the way it's being applied, at least by the district courts, almost all diagnostic method claims are patent eligible, but that doesn't have to be the case. Sequenom is the example, and I understand the Federal Circuit didn't support the patenting of Sequenom, but I'm not too worried about that, because there were actually factual distinctions that could be made. The office has experience in telling the Federal Circuit when they think they're wrong. I'll remind you of In re Bell and In re Duhl, in which the facts of the second case were used in the face of the first one to continue to say that gene patenting would be obvious. And the current spate of Supreme Court reversals of the Federal Circuit shouldn't make the office shy for telling the Federal Circuit when it thinks that they're wrong. The fact that the Supreme Court did not grant cert in the Sequenom decision, I think, shouldn't be taken as a belief that, in fact, the Patent Office got it right. I think that the court seems to be very happy, as in the Quozo case, to think the Patent Office is actually getting it right. I also think that if we don't give provide the grist for the mill, if we don't provide patents that can be challenged, even on eligibility grounds, the court, if it really intends to be just doing the contours, is not going to get the opportunity that it needs to decide, in fact, where those contours should be. And so I don't think that it's reversal from below to say that when the office applies its expertise to these matters, of which it has particular expertise, that they may come to a different decision that courts may have in other cases. But every case has its own facts, and the application of the law as the Patent Office understands those facts gives the office the opportunity to contribute in determining what should and what shouldn't be patent eligible. And I'll end my comments there.
All right, thank you very much. And our final speaker this morning on our second panel, is James Reed. Mr. Reed?
Thank you very much. I want to start by just thanking the Patent Office for this invitation to speak here and contribute to this very interesting discussion. I'm a patent counsel at the law firm Squire Patton Boggs. I draft patent applications. I prosecute patent applications. That's primarily my area in this field. Before I say anything, let me state that my views here are just my own. I don't speak for the law firm Squire Patton Boggs. I'm just an interested participant and want to just share in this discussion of this subject matter. In the last panel I heard, and I didn't plan on opening with this, but the idea was, I believe it was, is it a binary question, abstract or not? It seems to me that in the Alice opinion, the court says quite clearly, every patent claim is directed to an abstract idea at some level. So, and we also know from that case that the exclusionary principle, that is the abstract idea exception and the other areas that are considered excluded subject matter for patent eligibility, the concern came from a concern over preemption. Is the patent claim essentially claiming what the Supreme Court said were the basic tools of research and development, or was there something more to it than that? Is there actually an improvement being claimed? And is there a contribution to the art? The whole patent system is based on the idea that you grant a patent to promote the sciences in exchange for disclosing your invention. That is an improvement in the technology. We will grant you a limited monopoly on those rights. Turning now to the Federal Circuit cases, I want to focus on the triad of cases, Enfish, McRow, and Amdocs that came out this year. It had been 2 years since Alice was decided that we really didn't have any idea what needs to be in a patent claim subject to the Alice Mayo test that will make it patent eligible as not directed to an abstract idea. We first got a clue of what type of claim that could be in the Enfish decision. The court looked at the claim, and as we know, as prior speakers have mentioned, that step one is a meaningful part of the Alice Mayo test. The limitations in claims are meaningful, and when you undertake part one of the Alice test, you have to take that into consideration before just deciding whether it's an abstract idea or not. In the Enfish case, the non-abstract idea was an improvement in computer functionality. How did the court arrive at decision? I think this was an interesting decision from the perspective that as we all seek to understand when will we have a definitive test that won't be so dependent on the technology field implicated by the claim. That's essentially what we're after here, right? We don't want a test that is so dependent on the technology field, the descriptive nature of a claim to decide future cases, the common law approach. The court looked at the claims and it read a patent, and as we know, the Federal Circuit, they look at claims and then they confirm their understanding of a claim through the specification. It struck me as helpful and I believe insightful in light of the Supreme Court precedent that the Enfish court saw that the patent was really had a narrow focus. The limiting aspect of the claims, as we know, was this self-referential table or database, I forget exact words, that was the patentee saw was the solution to the drawback in the prior art, which was a relational database. They're inefficient in storing and reading data, and this was the patentee believed that a self-referential database would solve those problems in the prior art, the technology prior art. It's talking about an improvement over technology. The specification makes that clear. Self-referential table is viewed as one and the same as the invention. At the conclusion of the Enfish case, the court says, this is clearly not ineligible. This is not an abstract idea. Disparaging marks in the prior art, the improvement over the prior art that it makes very clear in the specification is enough for us. This is not an attempt to deceive one by the draftsman art. McRow case came out 4 months later, I think along a similar line. The McRow case said you cannot simplify claims in step one. They're meaningful claims, citing Enfish. In the McRow case, the court took it a step further towards this kind of goal of arriving at a test which would make the examination procedure much more tractable and implementable for examiners, not making it dependent on a technology field. The McRow case looked at it and said, the specification seeks to solve a problem. The prior art has this problem. Tedious, time-consuming step that requires a person, a human being, to decide. In the case, it was allegedly admitted that it was a subjective process, and it solves a big problem here. You take a subjective process, you replace it by by rules that allegedly obviate the need for a person to do this step, and you arrive at a much more simpler process. This is the solution. This is a technological solution. And so the court then arrives at essentially the same conclusion, in my opinion, which is this is a problem and a solution. This is a technology problem. There's a technology obstacle that's keeping you from arriving at the right result. And the claim is limited to that solution, to the technology problem. In that case also, we know that there was arguments for how the claims were preempting the prior art. In other words, you have a human being that's performing these rules, and the rules that the patentee arrived at, well, that would have been the same types of rules that anyone would have arrived at. That was not proven. There was insufficient proof to prove something like that. I think it would be extremely difficult to prove something like that in the ordinary course, and setting aside the implications of what they may mean in the context of a motion to dismiss. I think it's more interesting to look at that case and say, look at how the court tried to describe, well, the preemption concern. This is significant. And what is the preemption about? Preemption is about claiming a method for solving a problem as opposed to just stating the result. And claims to preempt only state the result. And I think that's the more workable way of approaching this. Of course, in MDOCS, we found out that the Federal Circuit is not total agreement on that. They're still looking at cases, but I think if you look at the MDOCS case, when they select their case that's most similar and reach a decision, they go back to the same test that McGrow is suggesting. Thank you very much.
All right. Thank you very much, Mr. Reed. My first question is directed first to you, Dr. Auth, and I thought I heard you say something along the lines of a technological test or technological requirement. And so my question is related to Mayo, which I'm glad people raised this morning, because I think that Mayo struck people as odd when it came out, because it was the first case that I think many of us had seen in a long time where the court focused on what I'll call the marginal inventiveness of the claim, and I don't mean that pejoratively, but the difference between what was claimed and what existed in the prior art. And so my question is, if we move to something like a technological requirement, is it fair to follow a case like Mayo and look only to the marginal change in the claim? Is that where the technological advancement has to be, or is it as on the claim as a whole?
Well, it should certainly be looking at the claim as a whole, but the term I was using was technical improvements, and that was based upon what we've seen in McGrow and rapid litigation. And they're basically looking for some specific recited language in the claims that is a particular application of the law of nature. And so you use the technical improvements, or that's the language they use. And it's very similar to what others were saying about the language that the Europeans use of technical effect. And so it's a very low bar. And it really is just saying that you're claiming something that's described in the specification and is particularly something that is an application of a law of nature, rather than trying to claim the result itself and the law altogether. So using the concept of an application of knowledge as a way to sort of bookend what it is you're allowed to claim, and the concept of preventing preemption, we hope that you can find a middle ground for what should be patent eligible in between.
Okay. Yeah, Shira?
So this is also for Ms. Auth. So I'm interested in your suggestion about a sentence that would be added to Section 101. Could you describe a little bit more what the interplay would be, the intended interplay between that and judicial exceptions, the extent to which that would substitute for existing judicial exceptions or preclude future ones being developed?
You know, I think that our proposed language is really not to address, it uses the current judicial exceptions, the law of nature, natural phenomenon, abstract idea, and basically is trying to define in some more useful manner, rather than just saying it cannot be those things, and say something in a positive way. One of the earlier presenters said, look, the problem with the current test is it's a negative test. And so you know what it can't be, but how do you figure out what it can be? And so the language that NYIPLA is proposing actually comes from the Supreme Court's decision in Myriad and was actually relied upon in rapid litigation, this concept of the application of knowledge or a law of nature. So it's a low-level way of saying this is a use of this law of nature rather than the actual law of nature itself.
So we had a question online that I'll sort of paraphrase, which is, does anybody in the panel think that in making these decisions, and given that we're sort of dealing with the stately evolution of common law, that the USPTO should forge a path based on what it should do in the gray areas? And what I mean is, should it lean towards patentability or not patentability if it can't figure it out? And I have no personal view on that at all. Speaking from the agency, it's just something I've heard brought up on the outside, and there's two ways to look at it. One way is if we grant a patent that perhaps we shouldn't have granted, it can't get tested until it goes into litigation. The other way to look at it is if we reject a claim that arguably we should be issuing, that can get to the courts much quicker because it can get to the courts through a direct path from that rejection. And I'm just wondering if anybody on the panel has thoughts on that.
And, you know, paradoxically, the post-grant review and inter partes review and all of that, which people complain about all the time, short circuits that problem. I mean, I would say that given the importance of patents, especially to small companies, that erring on the side of when you get to a gray area, granting a patent with sufficiently narrow claims. I mean, I think that the idea is in the gray area, the grayer the area, the less broad the claims can be, because it's harder to get over 112 and 103 issues in that instance. But claims of proper scope, if there is a gray area, then they can be challenged within 9 months with PGR, and that allows you to bring Section 101 issues, and under IPR, under 103. So I realize Justice Kagan thinks you guys are patent happy. I think that's a good thing. But I think I would rather see the office err in those really close cases on the side of patentability than the other way around.
I would tend to agree that the Patent Office should really be focused more on the other substantive areas, and that 101 should really be, as I said, a low bar. And so long as, and a way that the Patent Office can move forward with this is to really be very particular about the technical applications of a law of nature that they can find within the claim, and to be constantly focused on, is there something specific about this particular invention that's in the claim? Rather than just a general concept that's in the claim. And so specificity, I think, is the answer. And, of course, focusing on the other substantive parts of the statute.
I think that moving towards the gray area being patentable is perhaps a way to go, but I think really have to be cautious about things. It's a common law situation, common law case decision situation we have right now. Let's not forget that over the past year, we really have made some strides in trying to understand this test. A year ago, we had no clue about what Step One was about and how you went about doing the test. If you look at how the district courts were deciding what the standing law was, it really was very little substance, and I think there's a lot more now. We have to give it time. You know, after 100 cases are decided by the Federal Circuit, will they then come together? It's clear right now there's a big division between the justices, and of course the big fear here is we don't want to arrive at a rule that can be evaded. Comply with the rule, but not with the spirit of the rule, and that is avoiding patenting abstract ideas. Have to keep that in mind, and I think you need to give it more time before we can really arrive at some way of looking at it in a systematic format.
I think just to echo some of those comments, I mean, maybe in that gray area, maybe a hybrid approach is perhaps the best approach because, you know, if you have examiners who are issuing rejections under Section 101, at least what's happening is there is an abstract idea that's being articulated and the applicant is forced to say, you know, either why it's not an abstract idea or what the claim adds that's significantly more. That additional clarity can only help later prosecution and later litigation as well. So, you know, I think maybe the answer is to push a little bit, but not to put your foot down.
Well, thanks. I was going to take us back to the earlier, the suggestion for the proposal that, you know, there be a provision that says that it basically has to be a practical application of, for lack of a better word, the judicial exception. The one concern with that would be that you still really don't define what an abstract idea is. Is it preferable to have it defined in sort of the common law basis where you look at the cases and you see which ones fit better, or would you prefer, I'm going to say, another sentence which specifically defines what is or is not an abstract idea?
It's a really good question, and we actually debated it for quite a while, whether we should have something in there that specifically sets out particular classes of things that should be allowed that are applications of laws of nature. And then we thought, gee, how presumptuous of us to think that we're going to know what those things are in 50 to 75 years, let alone 100 years. I mean, think about 50 years ago, could they have imagined the computer programs that we're now trying to claim or business methods that we're trying to claim? I think not. And so that's why we left it open to future developments and thinking. And maybe the patent, I think that's where the Patent Office guidelines kind of can continue to help because those are more immediate and those are something that are an ever-evolving piece of work, whereas the statute really is intended to be something that you set up and you allow the bushes to grow around it.
My view on it is, like I had mentioned earlier, is I don't think we get anywhere by defining what abstract idea is. I think more the whole purpose of this law is to say everything is an abstract idea. Now, what more is there to the claim? What is the improvement in the technology? That's the whole reason why patents are granted. Look at it from that perspective. Is the patent really trying to solve a technology problem? I don't think it's generally too difficult for an examiner to look at a patent application and decide, is the real thrust, is it meeting a need like in the TLI case? Is it just satisfying a need in an asset industry? Or is it clearly trying to solve a technology problem and approach it that way? Where's the technology problem? How much of the monopoly, if we grant a patent, is just that technology solution, or is it more than that?
I have a question for Mr. Noonan. And you talked about the great number of natural products that have, issued between a certain time period. Is this something that's published, or are there studies that have actually talked about and listed patents that were issued early on that now would presumably not be patent eligible under Myriad?
Well, I guess where it comes from, there is actually the NIH study is published. And I think that a fair reading of the initial way that the office was looking at the Amazonic acid and things of that nature, would have made many, if not most, of those patent ineligible, because they're just literally, if you take the Myriad case to say that merely isolating something from nature isn't enough, then say Taxol, which is isolated from the bark of a yew tree, it would not be patent eligible. The problem with that is couplefold. One is trees don't get cancer. So the fact of the matter that somebody figured out you could get a molecule out of a yew tree that could treat human cancer, that's the human ingenuity part that I think deserves protection. And yet, I mean, I had a patent examiner say this to me, that, well, it inherently cures cancer. That the problem is when you get to that level, it's like the level of extraction, which fortunately I don't have to deal with in my practice that much. But the idea that if you get down to it, yes, everything inherently has its property. If the dividing line is that you need a human being to figure it out, then it seems to me that that's a good place to draw the line and say that should be patent eligible.
Does anybody on the panel have any other questions? Okay, well, thank you very much. Oh, I'm sorry. Oh. Wait.
Oops, one more.
Okay, well.
Not off the presses.
I hope it's good. Just kidding.
Doesn't say Harry Potter, does it?
It's more of an observation, but I think it's a fair one, and I'll phrase it as a question, which is, isn't the judicial diversity of our common law system what's keeping things lingering? That is, we sort of have these cases pop up in different courts at different times, and we have to use them all as data points, and the diversity of decision makers and of the facts of each case is what causes us to sort of stumble over having a very bright line that's easily applicable. That's a lot more than it says on this card, but.
Yes.
Okay.
Yeah, well, that's what common law is all about, right? The ability to build synthesis of law, and that's what this is. Patent law presents many different possible scenarios, and then the court has to find a test that worked for them.
Okay, well, I thank the panel, and we are going to take a 10-minute break and then start up again with the third panel. Thank you.
Thank you. That was good.